July the 13th, 2016.
Here.
Ms. Trinkler?
Present.
Mr. Howard?
Here.
Mr. Hart?
Here.
Ms. Hooper?
Here.
And would you read the notice of meeting, please?
Notice of the excuse me. Notice of the July 13th, 2016 meeting of the Collection Service Board was posted to the Collection Service Board website on June 14th, 2016.
Move to approve.
Second.
Motion's been made and seconded. All in favor?
Aye.
Okay. Our director's report, budget.
I have included on your director's report, of course, the last 5 years' history, as always. And below that, the year-to-date information. We're still just a little bit before budget or end-of-year close for fiscal year 2016. So the next report you get should have the final numbers with a more detailed information. But I'll just go over the May's information.
Oh,
Tab 35,
is it tab 35?
I believe so.
Am I way ahead of you?
Yes.
Last minutes were really long. There you go.
That's the little bottom dot. That's pretty cool. I didn't know how to get that.
I got you. Thank
You are
you.
so welcome. Okay. Get you here.
These newfangled things.
There you go. Thank you. You are welcome. All right.
Pitiful. I'd have 12-year-olds on the board.
Yeah. Be able to handle this.
All right,
Okay.
the budget plan for, excuse me. The budget plan for 2016, of course, is $203,000. So far this year, we have expended $77,874.38, and the revenue for the program is $237,760. Estimated cost backs, which have not been applied to those figures as of yet, is $74,980 with an additional $759 in investigative costs. Those on this next report, you'll have a complete breakdown, which would include a final number for cost backs. Cost backs include the administration above the. Also includes legislators, our legal team, and our investigators.
Just out of curiosity, what are the investigative costs? What types of money do we spend?
Investigating. Sometimes it can be as simple as sending out an investigator to serve notice for a formal hearing. It can be.
I mean, you all as a board don't spend much on investigative cost. It's typically if I can't serve someone via certified mail, I have to send someone out, an investigator out to personally serve the office or the person, or if we need to go look at some books and records, we can send an investigator out to look at that for us.
Okay.
So, but you all don't have
Much money?
No.
We don't spend much money there. Okay, thank you.
There's no legislative updates for this month. This is my last Collection Service Board meeting with you, and this is my last director's report. It's been a very rewarding and at times challenging 10 years with the state. I have certainly learned more than I could ever repay about leadership. We have made major accomplishments together in improving the regulatory process, and I sincerely feel this board has met its mission to provide reliable and efficient service and integrity and professionalism for those governed and affected by the industries we regulate in order to promote a safer, more secure Tennessee. I'm leaving on the cusp of many new successes for the program in efficient and effective government, including online applications and a customer service system that will monitor the program calls and react dynamically to frequently asked questions. I'm excited as I begin my next chapter of my career, and I hope you all will support the administrative staff as they continue to provide you with effective leaders for the administrative office.
Darn. We didn't know you was going, but good luck, congratulations, and thanks for all your,
I know
all
it
your
wasn't
hard and
very
diligent
long
work.
here, but I have really enjoyed working with you all.
I miss you.
All right. Just thereafter, you should have some questions that our administrative staff have for you. We have examples there, and I'm going to let Sarah talk a little bit more detail about this. It's really, we need to create some FAQs for when people call in and how to respond to their questions. So if you can help us with these, that would be very, very helpful.
I put both of these in front of you guys. There's two pieces of paper. One says Collection Agency Board Licensing Scenario, and the other one is new FAQs. I work a lot with Aisha, who's over here on your right. She helps with all the collection stuff, and so these are just some questions and some scenarios that have come up a lot recently, and so we wanted to put them in front of you as FAQs for you to change. You know, I'm not in the business, so anything that's on there can be changed. And then with the scenario, there's just some questions that Aisha's laid out that she would like for you all to answer so that she knows how to answer those when the phone calls come in.
Let's take just a few minutes and review these, and then when we get all through with it, we'll ask the questions.
Some comments on one of the questions.
I'm sure you do.
Good.
Hey, are we through? Everybody reviewed it? Wants to begin a discussion on, let's take the LLC locations question first. Steve?
That's a pretty good response, but if it's a subsidiary and it's a separate entity, there are subsidiaries that are consolidated without preparing their own financial statements. They're called disregarded entities. And so it's not necessary, but they need to let you know that. One question you could ask them is, do you file a tax return for that location? If they file a tax return for the location, that location needs a financial statement because it's a totally separate company. But if they only file a tax return, federal or state, for the home office, then your solution's a good one because license the headquarters, and those are just dialing locations. I don't recall, Bart, if we have anything about separate locations within the state of Tennessee, if each one has to be licensed, as long as, I don't recall anything about that.
Elizabeth, you maybe remember, but there's been this discussion before about companies in Tennessee and then companies out of Tennessee with branch offices. And I think there is something in the statutes about branch offices, and I believe that we determined that if all of the offices were in Tennessee, they all have to be licensed. If there are offices in other states, they don't have to be licensed, but they have to qualify as a branch. And that was when we had collection service manager licenses. So I'm not sure what difference that would make right now without managers.
Without managers, it makes sense with managers, but without managers, if they have a location in Tennessee, that location should be licensed, or the whole company should be licensed, because they're collecting in Tennessee, obviously. Anybody who collects in Tennessee, office or not, has to get licensed here.
That's under 6220-105C. It essentially says a licensed collection service maintaining more than one place of business within the state shall register each place of business.
Registering or licensing is a different
So,
thing.
and I think that's where they essentially register them, but they don't need to license them. But what if there are more than one location outside of the state?
We don't control those locations.
If they're collecting
They're
debts
collecting in Tennessee, we do.
Yeah.
Well, then they need to notify us of any location collecting debts in Tennessee. Now, if they're on one system and someone from a Georgia office dials into Tennessee and the main system is in Tennessee or in Georgia, you can't know that somebody from that office dialed in because they don't see it. They're just dialing numbers. So the whole company has to be licensed if they collect in Tennessee. I don't see how we can differentiate. If they have an office in Tennessee, of course they have to be licensed. If they don't have an office in Tennessee and they collect in Tennessee, they have to be licensed. That's still a separate question. Then is it a separate company? If it's a separate company, each company has to file a license, would be my opinion. Because that's an entity and it has its own financial statement, it has its own responsibilities, it has its own liability. Because if you set a company up to protect you against liability, you can only sue that one company, you can't get the parent. Well, each company should provide a license. And a test to find out if they're a company is, do you file a federal return? Do you file a state return? If they don't, then they're a branch or a wholly owned subsidiary or disregarded entity. The company should be licensed. You okay with that?
I think that's right on the licensing, but then also they still need to register those locations. And I think you need to be
Have
able to
anything?
see, and I think that's what that statute is saying, that if you have branches, we need to know where they are and the address and so forth.
What about branches out of state? Do we need to know those?
If they're collecting in Tennessee, I would say.
If they're calling in Tennessee, then they'd have to have a license. And have to have a bond for each collection office?
No.
They would have to increase their bond depending on the
Number of
collectors.
employees and total volume. Because if you have a wholly owned branch, giving notice of the branch is no more than saying I have branches in these states. In the question, they can't allocate, they can't tell you how much is collected in Tennessee. That's pretty much evidence they're on one system and they're not dialing by state. They're not dialing by location. They're in the state for presence and people, but they could dial from anywhere into Tennessee. So they may not be able to tell you how much is in Tennessee.
I think another question comes to where does the debtor send his money, and does that branch office maintain a trust account of its own? If they're calling from a registered, we call registered branch, and they tell the debtor to mail the check to them, where does that company put the client funds?
Necessarily have their own trust account, but that would be another indication that they're a separate company.
I think they have to have a separate trust account. Wherever the money goes, the money has to be divided at that time.
That's a good question. If you send the money here, if you send the money to another location.
I've seen some companies allocate money in the trust account, but some companies remit it straight to the clients. So it's kind of like it's just remitting straight to the clients. It's not going in.
So when they're collecting, they're telling the debtor to mail the check directly to
Correct.
XYZ company?
Yes.
Yeah, that's one method of operation. Another method, more popular, is receiving the money into the office and placing part of it in the operating funds and the other part in the trust account. The money that's owed to the client's placed in the trust.
And on the applications, it states if they don't remit money to the clients, how do they process that? So when I send the information up to the financial approvers, they'll be able to compare that for processing.
A question there, because what you're talking about is first-party collectors and third-party collectors. We regulate third-party collectors, but if a company is a third-party collector and does first-party work, when you do first-party, you're calling in the name of the client, and so their employees tell them to send it to the hospital or send it to the company. But I don't know, I don't want to run out a limb, but I don't think we regulate first-party collections because it's essentially the client, the actual first party who's collecting it. They just do loan staff or do it in their name. So only if it goes to me, only if it goes to the collection agency and they handle the funds and remit. The way they do that is they know how much was collected by the client because they run on the client system, and they bill them a percentage of what they got. That's how they get their money.
Some agencies, I assume, Asa, is that some agencies call in the name of the agency and then tell that consumer to mail the payments directly to the client. Is that right?
We've seen some companies where basically they're just sending out notices that they owe a debt, but they're not necessarily collecting on the debt. So I see a lot of those instances where they're doing that.
Letter service guys.
I think that's
Letter series. They just drop.
Yeah,
letter
but even
series.
so, some of the, particularly major banks now are requiring, so for example, if we were collecting for Chase, we may have to have the money sent to a lockbox, and then Chase will sweep it every night. And though I guess it's technically a trust account, the money's not being sent really to any location. It's going to, I mean, it is being sent to a location, but obviously it's a lockbox. It could be anywhere. It could be in Delaware, or depending on what the client's asking for. So I think what I'm hearing is it just gets tough to really figure out what they're doing and where they're doing it. So I think, Steve, in my opinion, what you said about the tax return is a big part of it.
The issue is we want to, I guess, and I don't know why we want to know every one of their locations in Tennessee or out of Tennessee. But if it's a company whose headquarters is out of Tennessee and they have a Tennessee branch and the money goes to them, then that branch, they're collecting in Tennessee, they need to be licensed. But I don't see a reason why we have to have them tell us every one of their branch locations. What value is that if the headquarters is licensed? For example, some agencies let people work out of their home. Is that home now a branch of the agency and you got to report everybody who works out of the house? You know, that goes to a level of absurd at that point. We got to control the trust account, and we got to control the collection agency. The fact that they have people scattered making calls in Tennessee, they're under our jurisdiction.
Well, I think that it is a changing map. I know back in the day, the reason we put that in there was because we did have the location manager, and we were trying to determine if there were some bad practices going on, you know, where was it coming from? Also wanted people to be able to identify, you know, kind of, you know, where this call had come from or where they thought this person was. But
Have
I think it's less important to me to know about the trust accounts because you might have multiple locations with separate trust accounts, but they still only file one tax return. So I think it's more important to, if they file one tax return, then that's it.
one license.
Yeah.
What if the branch has the money sent to the branch?
Well, you can have one company that has multiple trust accounts, but they only file one tax return. Does that make sense?
It makes sense, but there's nothing in our statute that says tax return.
That's true. I do think it's burdensome for the consumer, though. You know, if they're trying to figure out, if you've got, you know, one company that's got multiple branches and multiple trust accounts, and, you know, they might be called, you know, Company A Nashville, Company A Franklin, Company A Columbia, and then the consumer doesn't know whether Company A Nashville, Company A Franklin, or Company A Columbia has been the one to harm them. I think it might be difficult for them to, you know, make an issue of it.
I mean, that's probably where it's going to come in for us when the complaints are filed. You know, do we have to look at it and say, okay, this was filed against Company A Franklin, but that's essentially HQ, and so we need to turn the complaint against HQ instead of Company A Franklin, or if they get a call from Company A Franklin today and a call from Columbia tomorrow, are they going to know this is the same company? I have a right to file a complaint. Or who do I send my letter to tell them to stop calling me?
And if they file the complaint against the wrong one, what's the consequence of that? I mean, if you file a lawsuit against the wrong person, the lawsuit gets dismissed. So I'm not really sure what the consequences are. I just want to make sure that we're not harming the consumer by over-regulating.
And that could absolutely happen here. If we have a complaint filed against Company A Franklin and it comes to me and I reach out to Company A Franklin and say, can you show me where you sent this letter? And they can say, yeah, we can show you our file. We never sent a letter to them. And it actually came from Columbia. Well, then I have to dismiss it because there's nothing to go on.
If it's the Columbia location or the Columbia company?
If it's like Company A Columbia. So if Company A Columbia sent the letter and it says Columbia, but then they got a phone call from Franklin and the person's confused for some reason and they file a complaint against the wrong person.
That goes back to the entity, because our beef is with the entity.
Right, and I think
every
that's
case,
what we're
not
going
the
back to is
location.
the headquarters.
Yeah,
is that
the entity who controls the money and controls the trust and set the other location up for dialing convenience. If they file an extra return and they're a separate entity, then they should be licensed, to me.
But what if they don't file what if Company A files one return, but Company A location Franklin has a trust account, Company A location Columbia has a trust account, and they're both calling, and the consumer doesn't even know that Company A Franklin has called, and the consumer Googles it, and Company A Columbia comes up, and then they file against Columbia.
They're still filing against the company. Now, if Columbia is a separate entity, then they filed wrong. But if it's all one company and it's just a branch, I imagine a branch could have a separate trust account for convenience or a sub-trust account for convenience. Just because if money comes in over the counter, they have to have a place to deposit if they don't want to mail cash.
I think maybe using Company A Columbia and Company A Franklin may be confusing it. Both of those locations must be licensed because they're operating in Tennessee.
If it's just one company, why does each location have to be licensed?
Because it says each location must be licensed.
Because each location must be registered.
Registered.
So that's where we're going back to is if they file one tax return, they're only going to file for licensure one time, and then they'll have their branches that are registered. So then it's just going to be back to us to say, here's who the complaint should actually be filed against.
But if it's, you always file against the headquarters. You always file against the entity. The fact that they're in Columbia just doesn't matter. I don't know that it shouldn't matter for legally filing, because the person who called could be out of state working for the Columbia office and the headquarters in Nashville. It's just one company.
It seems to me we might just need to go back to how we have people apply and renew, and include on the application a list of all branch locations or all locations, and if it's a company with more than one location, and all the trust accounts, so that if there is a complaint filed, really we have the resource to go back to. This would give them the opportunity of having to pay for less licenses, but if they include all their branches on their license, you know, basically registering all the locations, we can add them as addresses in our fields.
They need to tell us about every trust account they have that's
Right.
for Tennessee deposits.
Right.
North Carolina requires a separate trust account for anyone who collects in North Carolina, and called a North Carolina trust. Tennessee doesn't require a separate trust account for anyone. You can have one trust account and collect in 5 states. But if a location has a trust account, or if a company has multiple trust accounts they deposit Tennessee money in, they should tell us about that.
So I don't know that that's specifically clear on all the applications. In this scenario where we're talking about companies that have multiple locations, they may be, well, this company has applied and got a full license with regards to this, with this trust account information, and this company may have used the same bond and the same basic information, but the address is different and the trust account is different. And really, if the companies are affiliated and there is an overarching parent company.
When you said the companies, whenever you use the word companies, you're talking about a standalone entity that files its own return. Right. If they're separate companies, of course they have to be licensed.
Right.
But if they're branches of the main company.
Yeah, that's what I meant to say. I'm sorry. But if we have multiple branches, maybe we should not be registering each of them as, or licensing each of them as a separate agency, because that's what it comes through on our applications now, is that they're applying separately. So PennyMac may have 4 or 5 licenses based on their multiple locations.
And it comes to an issue when they submit the financial statements. It's the same financial statement for one company, but multiple locations. So we can't really figure out if the trust account is solvent enough to pay the clients if anything were to happen. So that's been one of the main issues I've been having.
But the attorneys, it's the company, not the branch that's liable. The overriding person who has the federal ID number, that's the company. And if they have 5 trust accounts and they all add up and they're solvent, it's that entity that has to pay. If we try to look at each trust account and make sure each trust account's balanced, I mean, how could we ask for a financial statement on each location if it's a subsidiary?
Well, and I think like what Aisha's saying is that we're getting, like in this scenario, there's 3 separate locations, one in Texas and 2 in California, and they were separate companies. So file their own return, but one of them is called the headquarters. And so they didn't know if they needed to file one application that would cover all 3 of them, or if they needed to file 3. Well, if they file 3, they were going to submit the same exact financial statement for all 3 applications. And we told them, we were like, you can't submit that. We need individual. And they were like, well, we don't have it. So that's the issue that she's coming to, is that people are looking at her and saying, we don't have that information. I mean, I came from the accounting. I came from the accounting field. I know they have the information.
Yeah.
So, but
they're separate companies, separate federal ID numbers for each place, and they don't have a financial statement?
And that they can't break it down because all the money is going into one type of accounting system. So although they allocate funds at a particular location, it all goes into the same accounting stuff. So when they file financials, it's just one financial statement.
Then they're probably just one entity.
they're probably only filing
Yeah.
one tax return.
There are only one federal ID number. Ask them a question. How many federal ID numbers do you have?
That's the question that
Yeah.
you're going to have to start asking is how many federal ID, how many federal tax returns do you file, and then go from there. And then that is the person that needs to be, like in this instance, that's the person that needs to be licensed in Tennessee.
Wherever the federal ID number has their address, that's who we want to license.
Yeah, I think that'll help a lot.
Yeah.
You think,
That makes sense.
Aisha, do you have any other questions on your?
Ask. Sorry. Does that help?
It does help. I had another question. Well, as far as the surety bond goes, 1 to 4 employees, 15,000, 5 to 9 is 20,000, and any 10 or more is 25,000. If they're licensing headquarters for solicitors, do they need a bigger insurance branch, like surety bond? Do they need more coverage?
They should cover all their solicitors because a person in California can call Tennessee.
Yeah, but 10 or more, so say they have thousands of employees, will that $25,000 cover the thousands of employees?
Have anything above that, do we?
I don't have-
All the statutes.
That's all
That's all they
have.
have?
Yeah,
Okay.
that's all we have.
That's
Yeah.
all we can require, so.
Okay.
But if the headquarters say, well, we don't have any collectors, so we don't need a bond, that's not correct,
Wrong.
because they have
Yeah.
their branches in, yeah.
Yeah, that's wrong.
Does that answer that? Okay.
That was easy.
Yeah.
Isn't that easy? Is this,
FAQ is going to be something
Okay, I got
different.
you.
And so you all just need to read through that and make changes or suggestions if you don't like it.
Get a comment on it?
It's absolutely okay.
We're doing this now?
Yeah.
Number one, you pretty much quoted 6220-106, a personal or corporate financial statement. Is a reviewed, compiled, or audited financial statement. A personal or corporate financial statement is not something that's reviewed, compiled, or audited. It's something that's prepared by a CPA. And the CPA has to sign it. I didn't see in 62-106 that there is a requirement for a report. Now, if they send a report with the financial, then we have to read the report to see if it's qualified or not qualified, because that can affect their standing and their ability to do business. But there's a situation that I'm very familiar with where a CPA works for the company, and that CPA should be able to sign the financial statement. For us to define a financial statement as something with a balance sheet, actually, the financial statement is the balance sheet. The income statement is the attachment. It's a schedule of one line on the balance sheet. So we got that backwards. But we shouldn't define it because the CPA is going to prepare the financial statement and sign off on it. If they sign off on it, it's a financial statement, or we have recourse. I don't know that we can require, and you also use the word independent licensed public accountant. Well, that goes to the issue of the CPA that works for the company. They're not independent, but they are a CPA. And the way it doesn't say independent in the statute, it says CPA or licensed public accountant. And I don't believe Tennessee has any more licensed public accountants. They've all been converted to CPAs. I know that's in the law, so we might want to write it, but
We'll have to leave that in there, but, I mean, you're correct on that. So if you were going to write this FAQ, how would you write it? Because I know Aisha gets a lot of questions on this one, too. This all stems from her questions.
I know the law says corporate financial statement, but that implies it's an Inc. Now there's LLCs and all kinds of entity structures. But if we're quoting the law, then we should use the word corporate. But if it really is a business financial statement that we're looking for, personal or business. If it's a independently owned entity, if it's just a sole proprietorship, then it is a personal financial statement they're sending. But if it's an entity, then it's the business of financial statement without defining what the type entity is. But I think if we just require, or we say, it just needs to be prepared by a Tennessee licensed CPA or public accountant, and we should actually require their number. I think we do. In the form, we have a place for their license number.
Right.
So when they sign, we can actually verify that they're in good standing if we wanted to as a CPA. But I don't know that we can require a report. It says additionally, a letter from the accountant attesting the authenticity of the financial statement must be included with the financial statement.
Essentially, by signing it, they're attesting to
They're
it, in my
attesting.
opinion.
Yes, they are. But if you're not independent and you sign the financial, there is a phrase you write on the financial to identify the capacity in which you sign it, but you are a licensed CPA. But any independent, any CPA working in public practice, they're going to provide the report because they're not going to sign the actual statement. They won't do it. They sign the report, and then you have to attach the statement to the report.
Questions stem mostly from, we get a lot of, we get several, not a lot, I should say. We get several people who have applied and they want to turn their tax returns in for financial statements. And we need a way to clarify that what we would accept as a financial statement and what we cannot accept as a financial.
I think the word's in there that we don't accept a tax return as a financial statement. That's correct. Even though a CPA does sign a tax return. Now, see, a tax return doesn't have to have a balance sheet, and the tax return doesn't identify the trust account. It just has one line for cash. We need to stick to the fact that we don't accept, and that's really our interpretation. It doesn't say that in the law. But we have to know about the trust account.
On this one, if we just said a personal or business financial statement prepared by a licensed public or certified public accountant, and then left Part B in there?
Prepared and signed.
Okay.
My question is, you have a brand new fellow and he wants to open a collection agency. He doesn't have a corporate financial statement because he doesn't have a corporation yet. He wants to he wants to open a collection agency and get a license. I suppose he could get a license, but I mean, he could file for a corporation, but I think in Tennessee you only have to have $1,000 to have a corporation. Will that suffice as far as authorizing him? And he doesn't have a trust account, doesn't even have any clients yet, but he wants a license before he goes to solicit for business, of course.
Art, a new license application requires a pro forma financial of your first 6 months of operations. So he may not have the entity structured, but he's given us a pro forma of what he's going to do. And on that, he's going to show a trust account, whether it's created or not. So he's going to have a company financial statement in the format. And that pro forma should be prepared by a CPA, because
Do we still require the pro forma?
I don't recall it being going away for not renewals, but new license applications. I don't know. The pro forma was?
Yeah, we don't have the pro forma anymore.
Then I'm wrong.
Satisfactory proposed budget of monthly operating expenses for the first 6 months of operation. That's one of the requirements on the application but there's no pro forma required.
That's the same thing.
So, I mean,
That's
that's a pro forma.
yeah, that's a pro forma. Yeah.
So it's still in mind, so.
Still in the
But
law.
But that's just
Yeah.
that's just a guess and a hope. It's not the financial condition of that company. It's just a guess and a hope. His financial statement would say assets $1,000, liability $0. That's it. Trust account $0. I just want a license so I can go out and ask for business.
There's a place on the application for them to specify that so the financial approvers know that when they see the $0 in the trust account. So we've licensed some companies that were brand new and didn't have any interest.
All right. Okay. Any more questions or discussion on that? Ace, did we answer your questions?
Yes, Thank you.
Thank you.
Number two, do you want to talk about two? I like how you've responded.
I had to take it exactly from a meeting, I think your last meeting that you had with Keeling.
I mean, that's pretty simple, isn't it? In my eyes.
Yeah.
The entity filing for the license, applying for the license, has to submit a unique financial statement.
And when you call it an entity, it's not a branch. It's the federal ID number entity. You're not an entity if you didn't get a federal ID number. You're not an operating company, basically. So yeah, that works good.
Okay, do we want to do the proposed rule or the legal report?
I think we should probably do a proposed rule, so there isn't any question.
Perfect. So we talked about this at our last meeting, prepping a rule for defining what a change of ownership means. So I went ahead and prepared this as a new rule that would be added. The rule is on page 2. And then essentially what I need you all to do is make any changes that you have to that rule or adopt it as it is. And then we will have to look at a few other documents on here, and we'll have to vote on those via roll call vote and make any changes that you have.
We're saying they're going to have to apply for a new license if they have a change in ownership.
Essentially, right now, our rules say if you have any change in ownership, you would have to reapply completely. And so we were just trying to say, if you have an aggregate change of 50% or more as a corporation, that's when you would have to reapply. That if you just had a small change, there's no need to completely reapply. We think it'll be a little more consumer friendly.
Yeah. So if Bart issues me stock in his company, it would not force him to stop and relicense.
Apply for licensure, yeah.
As long as control didn't change. If control
Right.
changes, then yeah, we want to know who they are.
Right.
Questions or comments, objections to these rules? I think it's good.
I have an
I mean,
interesting problem, but I'm not going to ask you now.
Say again? No.
I want you to tell me.
Are you ready for a roll call vote?
Yeah, no changes to the proposed language?
It's fine. No, change in control is pretty good.
Okay, Nicole, roll call?
Is there a motion and a second, please?
Yeah, so let's make a motion that we accept the rules as proposed in Rule 0320-01-.04. Change in
moved.
ownership.
I second.
Been made and seconded. All in favor, say aye.
Aye.
There
Need
must
a
be-
roll call
we need a
vote?
roll call vote.
Art Howard,
Aye.
Steve Harp,
Aye.
Chip Hellman,
Aye.
Angela Hoover,
Aye.
Elizabeth Trinkler.
Motion passes.
The next one is page 5. It's the regulatory flexibility addendum. I went ahead and drafted answers to these questions so that you guys wouldn't have to do it in the meeting. So if you'll just read through them, any changes, corrections.
That's it, yes.
Need a motion?
I mean, if you want to continue, the next page is the impact on local governments. I drafted that the board foresees no impact on local governments. And then also on page 7, there's some additional information that I went ahead and filled out. If you just want to read through all 3 of those, then you can make a motion to accept them all and do it in one.
Questions?
I want to ask our attorney something. Essentially, what we're looking for is a change in control. If there's a change in control, they have to file again. But if there's no change in control, they don't have to file. Is that correct?
Correct, because essentially a change of control would be more than 50%. So,
A change, the definition of ownership, it is a question. Is it who the stock or LLC interest is titled in? Because if you sold the entity to the same people, a corporation owns 2 guys or 3 guys own the shares. There's a third each. Then they form an LLC and they distribute it and they own a third each of the LLC. Do they have to get a new license?
I mean, in my opinion, I would say no, because there is no change.
Yeah.
It's the,
But when you said entity, or you can say entity, it ticked my head. I'm sorry about that. The way it was written. Of the stock, well, limited liability companies don't have stock. Anyway, sorry I didn't pick that up earlier. I don't know. I just thought a reference to control might make it tighter, more clear. But
any suggestion? I
think
mean,
it's very-
essentially, just so you all know, this is your first review of this, and it will go to the Attorney General's office, and they will review it. And if they have changes, they will send it back and give it to me, and then I'll come back to you with what the Attorney General says. And then it will go back to the Attorney General, and then to the Governor's office, and then it will be published, and I believe the window is 90 days for objections. And if we have 10 objections, then we get to start all over and have a rulemaking hearing. So this is hopefully the faster way. I'm assuming with the change being consumer friendly that we're not going to have many objections to people not liking this rule. So they could have these same concerns and they'll come back with those questions as well. So, I mean, if you want to address it now, we can go back.
On the renewal application, we ask for all of the owners of the entity, do we not?
Yes.
We do.
So if somebody has bought 10% of a company, the ownership hasn't substantially changed, so they don't need to apply for a new license. But if that person that bought 10% of the company is Attila the Hun, then we'll know that on renewal and can make our decision at that point.
Absolutely.
Okay. If there's no other questions, I'll entertain a motion that we accept the rule changes as presented by legal counsel.
so moved.
There's
Second.
And seconded, all in favor say aye.
Aye.
Do you need a roll call vote?
Do one just in case.
Art Howard,
Aye.
Stephen Harb,
Aye.
Chip Hellman,
Aye.
Angela Hoover,
Aye.
Elizabeth Trinkler.
Aye.
Thank you.
Perfect.
Good, that's good work, Tara. Thank
It
you very
is.
much. Legal report?
Yes. Do you want to jump into that?
Yes, ma'am.
Good.
Is that what's next on the agenda? Yeah, okay.
Okay. Well, just to let you know, I know the last time we met, we sent out a consent order asking someone to repay a complainant. Just so you know, they did repay the complainant. So it was they argued a little bit, but we did get him to do it, and the complainant was very happy, and he thanked the board. He was very happy.
Great.
So I will go through and just read all 20 complaint numbers, and then we can discuss as you wish.
Angela, most of us here on the board are used to reading these complaints. You're probably not. I tend to go through them pretty quickly and ready to move, but don't let me speed you up. If you need a little more time to totally understand.
No, I'm good.
Okay.
Okay. 1-2016-001891. 2-2016-008911. Number 3, 2016-009491. Number 4, 2016-002151. Number 5, 2015-022-3311. Number 6, 2016-021021. Number 7, 2016-021871. Number 8, 2016-021891. Number 9, 2016-022781. Number 10, 2016-022991. Number 11, 2016-023091 and 2016-023092. Number 12, 2016-023121. Number 13, 2016-028671. Number 14, 2016-029161. Number 15, 2016-029231. Number 16, 2016-029611. 17, 2016-029641. 18, 2016-032881. 19, 2016-033351. 20, 2016-029281. And just so you know, numbers 1 through 5 are represents from last month. We found out a few things after the fact that changed our recommendation. Number 15 is one that you'll want to be aware of. We also discussed the same respondent last month. And I believe 17 is the only one that I recommend an actual civil penalty on.
I'll have to recuse myself on 14, so when you call for a vote, however you need to structure it.
Okay.
Okay, here we go.
done, I would recommend doing items 1 through 20 as a whole, with the exception of number 14, and then do number 14.
Okay.
Have to talk about 15 again. Is it 15? Yeah, 15 again.
Maybe exclude 14 and 15 from the first vote. Hold a vote on 14 and then hold a vote on 15, and that way the minutes will reflect everything very clearly. Inserting my opinion into any of this dialogue.
Steve?
Yeah.
Okay. Are there any, is there any, other than 14 and 15, are there any discussions about any of the complaints that we've read? Do you have any questions? I'd entertain a motion that we approve the legal report with the exception of 14 and 15. And
I would make that motion, Mr. Chairman.
thank you, man. Thank you, sir. It's been seconded.
Second.
All in favor say aye.
Aye.
Okay.
Now, sir, I might make a motion that we accept number 14 by itself, so,
I'll second that.
Motion's been made and seconded that we accept 14 with the understanding that Mr. Harb declines to vote. All in favor say aye.
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 now, number 15. Do you want to get us back up to, I mean, I think it's easy to understand, but refresh all our memories on this. We can't find this company? I'm sorry, Bart, I didn't mean to
Oh, no,
take
you
over,
go right
but
ahead,
this
pal,
was
that's
one I
fine.
remember.
So, Mr. Harvey, you were not here last time we discussed this, but this is the same respondent that I called and was hung up on and yelled at when I made the phone call, and I was told to never call back. We located an address in Florida, and it doesn't exist. So I want to say they had over 3,000 complaints with the Better Business Bureau. I mean, and nothing's been closed on it. I mean, all these complaints are just unresolved. So, at this point, we don't know if we should just be looking at these and closing them out as we get them, because there's essentially nothing we have no one to go after.
We refer it to the TBI for them to investigate. Is that something they would even investigate?
I think we can refer it to the district attorney.
Send it to, the district attorney's office. We have a couple contacts over there, and if it's a case where there's a pattern and practice of unfair debt practices or fraud, they'll go after those instead of us.
It seems like fraud to me, but I don't know. So maybe we should call them and let them know that we've gotten these complaints, or send it over to them.
It's across state lines if it's in Florida, right?
They have a few locations. So there's a location in Florida, but there is a number coming out of Tennessee as well. But we have no address. A lot of it's coming from email, is what I've realized too from my background research on it. Just the Better Business Bureau had, I want to say like 100 different email addresses that were going at people. And I've seen a couple copies of the email. I believe someone in maybe the association, Tennessee Collections Association, he sent over an email that they had actually received. And it's, send your money to us, and it gives no address. No, it's just nothing.
Where would they send the money? There's no address to
There was
send.
no address. It was like, call this number,
Oh.
and then it's the number, one of the same numbers that I called. And they identify themselves as ACI. When I called, he said ACI, and I said,
When you ask them to send, when you want to send them money, they refuse to give you their address. They just say, well, give us your credit card number or your checking account number, and we'll get the money that way. It's the only way
I
you
assume
collect
that's
the
what they're
money.
saying.
Do any of them say that they're collecting for XYZ company? They're just saying send in the money.
Everything I've seen just says, call this number.
Yeah. I think it needs to go to the DA, and likely this company's out of Nigeria or somewhere.
Have you tried acting like a consumer and seeing how far they take it and what they ask
I
for?
have.
You have?
Yeah.
And that's what they went for?
Yeah, and I
Credit
call
card?
them and I say, what's this all about? And they say, you know what it's about. Send in or give us your credit card number and we'll take care of it.
Yeah, when I called, I didn't identify myself for the state of Tennessee the first time. And when they answered the phone, I asked a few questions, and then they were like, just click. It was like they knew what I was asking, and then when I called back, it was not nice. So.
Bad people. Give our industry a bad name. We need a special vote on number 15.
So, Mr. Chairman, I'll move that we ask the staff to contact the district attorney's office and allow them.
Second.
Motion's been made and seconded that we refer number 15 to the district attorney for their resolution. All in favor say aye.
Aye.
Ask a question. That is a great recommendation. What should we do with our open complaint? Should it be closed?
I think we should just flag them.
Close and flag?
Close and flag.
Can you make that in the form of
Yes, ma'am.
a motion and second?
Our motion, we close and flag these specific complaints. We don't want them to show, we don't want them to ding us on the job we're doing here, and that's what'll happen if we don't.
I'll make that motion.
Second it.
Motion's made and seconded that we close and flag the various complaints that we have on this company. All in favor say aye.
Aye.
So, Nicole, on that one, go forward, if we get these complaints again, would we administratively close them and send them over to the DA as we get them, collect them, or do we need to bring them to the board every time? Because I have a feeling this is not the last that we've heard of this company.
For discussion, I would recommend if it's the will of the board, since we already have kind of a decision on this, any additional complaints, we could have the complaint coordinator enter into our system, enforcement system, as a new complaint, and then basically open it and close it and flag it so that, we have documentation of each consumer complaint that was filed, and like administratively refer them to the Attorney General's office as we receive them. So there's more and more documentation going to the Attorney General on this specific, I hate to call them a company or agency, but this specific group of individuals who's decided to cause some havoc in Tennessee.
Can I ask a question? I think that makes a lot of sense to me personally, but what are we saying to the consumers when they file a complaint against this company? Are you going to be telling them in the future that we forwarded, this is a recurring?
I guess that would be our response, is that these complaints are now being sent to the district attorney's office for further investigation.
And we have stock letter we can send, like if we send to another department, we can send it to the consumer and say, we received your complaint. Thank you for the information. We think it's best handled by the Attorney General's office. Your complaint has been forwarded, and this is just a copy of the letter we're sending to you. It reads something like that.
Yeah. So the consumer is not left hanging. They know that we've done our part, but
Right.
that we've really done all we can do. Okay, and that's good, because now we have good record of receiving the complaints, but also they're not clogging the thing up. We don't have to go. Any updates you have.
Yeah, I'll keep track of them too, and I can report to you all how many complaints that we receive and how many we're sending over.
If we get really good information, like suddenly we're able to locate them or whatever, it can always be the discretion of the administration to present it to, send it through legal and present it to you. If we're like, I think we got them now, kind of.
I mean, yeah, that would be ideal if we, we'll watch for an address in Tennessee where we could actually send an investigator out to attempt to personally serve. I mean, with the address being out of state, we can't send an investigator. I mean, they would love for us to send them down there, but.
Perhaps you should give them Nicole's credit card and follow the.
Just try it.
Yeah, and just track it through the system. You may be able to find out where that money goes.
Did I hear you volunteer your credit card? I did not.
Do we need a motion on that? I don't think.
Couldn't hurt.
Okay.
Couldn't hurt.
Entertain a motion that future complaints on this company administratively be closed and flagged and sent to the Attorney General, in addition to sending the consumer a letter advising him of our action.
So moved.
Is there a second?
Second.
Moved and seconded. All in favor say aye.
Aye.
New business, any other new business to come before the board? We have only one page today of visitors signing in. I'd like to welcome again I call you BJ for years, but Becky Givens, and Stephen Rust. Welcome, visitors. We're always glad to have members of the industry at our board meetings, and thanks for coming. Any other new business? Move we adjourn.
So moved.
Second.
Aye.
Thank you for your time today. I appreciate it.
Good luck.
Thank you.
Do you know what the next chapter looks like?
Did too.